Well, thank you so much for coming. Thank you so much for inviting me to come talk to you. I'm delighted to have the chance to talk to you about the First Amendment and my book and some of the current controversies that are going on in church-state law. I thought I'd start by telling you a little bit about myself so that you kind of know where I'm coming from. I'm the son of two New York Jews. I'm from Massachusetts. The son of two New York Jews who tried to raise me Jewish, but it never really took. And I did have a bar mitzvah, though the rabbi pushed me out of the way at one point. I'd just say it didn't go well. I became an atheist in high school, and I remember announcing this to my freshman English class, that I was an atheist. And then later in that very day, I was playing dodgeball in gym, and I broke my collarbone. And so I held off on any other public declarations of atheism for a while. But in college, I pretty much got over that, and I was an atheist, although I dabbled a little in Taoism and Asian religions, and I lived in China. And I went to the University of Chicago Divinity School in order to prepare myself for a career teaching Chinese religion, but it turns out my language skills aren't good enough for that. And so I went to law school, and I did law and religion when I was there, and now I've been teaching at Boston University, and I've taught there for about 9 years. And a couple years ago, over the dissent of a vocal minority, they gave me tenure, which is I don't know exactly what I think about tenure as a sort of an objective fashion, but from my own personal perspective, it's great, because it means you could do whatever you want for the rest of your life. And so what I decided I wanted to do was to write a book about church-state law, just kind of a fun book, not just for certainly not for scholars, not just for lawyers, but for just general interested people to know a little bit about what the Supreme Court said about church-state law. But even though I thought, I still planned on doing a fun book or whatever, I thought I would be writing it in my office like law professors do. But then I was, at the time, just completely coincidentally reading these books by people who had gone on the road in search of their obsessions, like Sarah Vowell. Wrote this great book called Assassination Vacation, where she went on a road trip to various places connected with the assassinations of various presidents. A very macabre book, but it struck me as a nice, I really liked it. And halfway through the book, I said, hey, I can go on a road trip. I have a 97 Civic that sort of goes. And so what I would do is I decided I'd go on this road trip to various different places where these big church-state cases came up. So I divided church-state law into 7 or 8 different big issues, and I went on one trip at least for each of those issues. So what I thought I would do for today's talk is lay out these 7 issues as I see them, and then tell you about the trip that I took in connection with that issue, and then highlight also a thing or two that's going on with that issue right now, to bring us up to date. And then after that, I'll also along the way read a passage or two, hopefully, and then after that we can take questions and have a conversation. So the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So there are 2 parts, the Free Exercise Clause and the Establishment Clause. The Free Exercise Clause has 2 big issues, I think, and the Establishment Clause has about 5, depending on how you split them up. So I'll talk about the Free Exercise Clause first. The Free Exercise Clause, Congress shall make no law prohibiting the free exercise of religion. The first issue is, can government burden religion through general laws? Can government burden religion through general laws? And the Supreme Court has said, yes, it can. In other words, if the government passes a law that says nobody shall use peyote, nobody shall eat peyote, and it applies to everybody, and there's somebody who happens to need to eat peyote as part of their religious ritual, that person's out of luck under the Supreme Court doctrine. That is the result of a 1990 case called Smith, perhaps the most unpopular case I can think of that the Supreme Court's decided. It's a case that united the ACLU and the Christian Coalition in opposition. But nonetheless, that's still the law, although it didn't always used to be the law. Before that, there had been a couple of cases where the Supreme Court held otherwise. There was this one case called Yoder versus Wisconsin, Wisconsin versus Yoder, involving the Amish. And this is the case that I investigated on my road trip. This is in the late 60s. The Amish there in New Glarus, Wisconsin, did not want to send their children to school after the age of 14. They thought their kids should be at home as part of their religious community. And the state of Wisconsin said, no, you have to go to school until you're 18. And the Amish said, no, we're keeping our kids home after 14. And the state said, no. And the Amish said, yeah. And the state fined them $5, the Amish. The Amish took this all the way to the Supreme Court and won. And the Supreme Court said that Wisconsin had no compelling interest in making the Amish send their kids to school after the age of 14 or so. So I went to New Glarus, Wisconsin, because I wanted to see what was going on with the Amish there and talk to them. Problem was that it turns out there are no Amish people left in New Glarus. They all left after the case. That's not exactly true. There was one Amish man left in New Glarus, and I got in touch with him. I called him on his cell phone. And he was recovering from a motorcycle accident. So it was a sort of unorthodox Amish man. We talked about the case, and he remembered the case from when he was a child, and it was very interesting to talk to him and his memory, his recollection of the case. And the Amish won, but the Amish didn't think of it as this great victory for them. They weren't celebrating their contribution to the First Amendment. They were just very happy that they got the government off their back. And that was what they were very interested and excited about. So it was nice to talk to him and learn a little bit about New Glarus. I also met one of the original plaintiffs from that case. His name was Aidan Yutzi. There were three plaintiffs. Yoder was one, Yutzi was another. Yutzi was the only one who was still living, and I met him in Missouri, in a small town in Missouri, and we talked about the case, and he did try to convert me, which didn't go well. But, I heard him out, and I talk about him a lot in the book. Very interesting person to talk to. Right now, I was thinking about what I could mention with respect to this issue that's going on currently. There's this fascinating case from Utah. I should say that Congress and some of the states have passed statutes to get rid of the Smith decision and kind of go back to the old way of when Yoder was decided and require the government to have a compelling interest before it burdens a religion through a general law. These statutes are called RFRAs, Religious Freedom Restoration Act, and there's one that applies to the federal government. And there's this great case in Utah, fascinating case involving a man who is not a Native American, not a member of a federally recognized tribe, but is nonetheless sees himself as needing to participate in these religious rituals of Native Americans who he's very close to. And he was arrested 10 years ago and convicted of owning an eagle feather, which is illegal under federal law. And the only way anybody can obtain an eagle feather is if you are a member of a federally recognized tribe. You can apply to this very bizarre federal agency outside of Denver that collects dead eagles and eagle feathers and then sends them out to Native Americans. But this guy, he wasn't a member of a federally recognized tribe, and so he couldn't do that. And so he's defended himself on the basis of the Religious Freedom Restoration Act, saying, I need to be able to practice my religion. You don't have a compelling interest in prohibiting me from owning an eagle feather. And the government comes back and says, our interests are, one, to protect eagles, and two, to protect Native American culture and religion for people who are members of federally recognized tribes. For somebody who teaches environmental law and administrative law and religion and law, it's an absolutely fascinating case. That case is in the 10th Circuit now, and we expect a decision, or I expect a decision, anytime. The lower court held for the man against the government. And there was a New Mexico connection to that case. At one point, there was a New Mexico defendant who was joined with him, I think, but I can't remember exactly the details. Anyways, I should move on to the second issue involving the Free Exercise Clause, which is discrimination on the basis of religion. The government cannot discriminate on the basis of religion, treat religions differently. There's a case from 1990 involving the Santeria in Miami. The Santeria believe in sacrificing animals as part of their religious ritual. And at one day, the head of this Santeria community announced that they were going to do this kind of in a more open fashion. And the city of Hialeah, Florida, did not like that. And the man announced the new policy on Friday, and by Monday, the city was engaged in creating these new regulations to basically ban animal sacrifice within the town.